Gonna start the recording in case anybody wants to look back at it. Does anybody have any questions about the first test that I could, I mean, I don't want to help anybody in particular, but if everybody's on the call or able to see the recording, if there's any questions anybody has. If not, why don't we, let's talk about that, let's talk about that case involving George Stephanopoulos. Tell us about that. I think you're muted.
I was watching news on the TV, and I had to go on YouTube to find out whether the story was posted. But the idea behind that story, what is interesting in that story, it's a story involving Donald Trump, where Donald Trump is accusing the NBC reporter, George, the presenter, of defaming him, as he said that is, he raped that lady in that notorious case. But Donald Trump is saying that he didn't rape the lady. He was accused of sexual assault. It's not raping the lady. And he said that he was defamed. And Donald Trump filed the case. But in that story, what is interesting, the expert is arguing that it will be hard for Donald Trump to win the case because Donald Trump is a public figure, and he has to prove that what George said had an impact, kind of negative impact on his personality. So that's what I realized from the story. And that's connected to what we have today about this case of New York Times vice Sullivan. It seems that it's hard for public figures to win the case involving defamation.
Yes, that's true. Because because of the standard that New York Times versus Sullivan set up. Are you able to hear me? You're sort of going in and out. Here, I'm going to try this without my. Okay, go ahead and say something. Are either of you talking? Yeah, it's not coming through. Let's see. Let me try again with the earphones. Let's see.
Yeah,
Let me
I'm
try
talking
again
now.
with the earphones. Okay, try again.
Yeah,
Are
can
you
you hear
just
me now?
talking? No.
Yeah, can you
Oh,
hear me
there.
now?
Yeah, there
Hello?
we go. Okay, I got it.
Okay.
Yeah. Yeah, you're right. I mean, it's going to be hard for Trump to win that because it is the New York Times versus Sullivan standard that applies. Actual malice, which means that reckless disregard for the truth, knowledge of falsity. Um, are you guys hearing me okay?
Mm-hmm.
Okay, good. So,
Trying to let my all right.
Oh, yeah.
where are you off to, Paul?
In my room.
Okay.
I'm gonna spray it. Just trying to find my RA.
Wait, what do you have, a wasp, did you say? Or
I think I have a wasp. I just heard like a bug noise in my room. I'm like, wait, that can't be good.
maybe your room's bugged. Ha ha ha.
Hopefully it's not bugged by
Um,
immediately saying here's a problem. I'm assuming it's illegal to place any cameras in someone else's dorm. I hope it's illegal.
is what legal?
I'm assuming placing hidden cameras in someone's dorm is illegal.
Yes, I think that would definitely violate a person's expectation of a reasonable right of privacy. Yes, I think so. Um, So the case that we're talking about is where George Stephanopoulos from ABC was interviewing a representative from South Carolina whose name is Mace, M-A-C-E, about why she, even though she has said that she was a victim of rape as a teenager, why is she supporting Trump, who has been found by a New York court to have and jury to have sexually assaulted Eugene Carroll, a writer, a magazine writer in New York City, 2 decades ago in a department store in New York. And so, what he's saying is that, well, the court decision didn't actually use the term rape, it used sexual assault. Although I think George Stephanopoulos showed the passage from the court decision that specifically said that this sexual assault was what amounted to rape. And so Trump's suing George Stephanopoulos for defaming him. And he is, Trump is definitely a public official or a public figure. He's no longer a public official, but he's a public figure. And so New York Times versus Sullivan standard of actual malice would apply. So he's got a difficult case to make, I think, given all the circumstances. What do you all think?
I think the comment is right. I mean, from that news story. But also, after hearing that and reading this case of New York Times and Sullivan, I was thinking about the political question when it comes to First Amendment and other kind of laws and court decisions. It seems that justice doesn't exist. Justice remains a theory, because if laws is there and someone is maybe has committed a crime and people are using like those kind of arguments to support what somebody did, I think justice is something debatable.
Justice is something what?
I think something debatable. It's not something that is straightforward. Somebody might be might have like arguments that can support him, but maybe the law can put him down. That's why I think justice is something that is not something doesn't exist. That's what I say sometimes.
And how does that apply to this case? Who's not getting justice?
I think not only in this case of Donald Trump, I'm referring to other arguments that we have seen in this class and other arguments from outside. If you see that somebody is maybe defaming another, and the one defamed may be a public official, but the defamation is confirmed already. But they say by using law, they say that this defamation is not confirmed because it's not going to prove that a component of actual malice. But somebody defamed a public official. Already the crime is there. But they are not going to punish the one who defamed, saying that it's not going to damage his personality. That's why I was maybe having a kind of comment and challenge when it comes to the application of laws and justice.
So is Donald Trump being not getting justice?
Well, I will not say that because laws are there. I was commenting on that, showing that even if laws are there, they may even undermine some people's rights. Because if somebody defamed another, and then they're using laws saying that this is not defamation, I see that as a challenging idea.
Um, well, yes, I mean, another recent defamation case that showed that even with the New York Times versus Sullivan standard that a plaintiff, a person suing for defamation could win is the Fox News case, which involved Dominion voting machines. Fox News had run all these stories suggesting that Dominion voting machines had been manipulated to steal the election for Biden over Trump. And Dominion sued Fox for defamation and got a huge settlement in the I think hundreds of millions of dollars. So that was a defamation case where the person saying that they were defamed won, despite the New York Times versus Sullivan standard of actual malice, because they were able to show through they were able to show through having um, obtained a lot of Fox news personalities emails that they knew that those news personalities knew that Trump's allegations about and the Trump people's allegations about Dominion voting were false, and that they had known they were false when they made them. That's why they were able to win. In the Jean Carroll case, Trump claims he didn't have any sexual contact at all and doesn't even know who she is. But a jury found that there was proof that what Eugene Carroll alleged was true. And so the law of the case involving that set of circumstances at the department store is that it happened. Donald Trump can say as many times as he wants it didn't, but there is a jury finding that it did happen. Of course, now Trump is trying to say, well, the finding was that I engaged in sexual assault. It didn't say that I raped her. And so therefore for George Stephanopoulos to use the term rape defames him. But due to the fact that Stephanopoulos actually showed on TV the paragraph from the opinion that said the sexual assault amounted to rape, I think that Trump has a very weak case. So let's see. Before we move on to New York Times versus Sullivan, Paul, do you want to talk about this this West Texas drag show story?
Oh yeah, let me pull it up.
I notice it
So
involves Walter Wendler, who used to be used to be here at SIU.
this is
Go
from
ahead, Paul. Are you still fighting your bug problem?
I didn't see the maintenance yet.
Say again?
I didn't see maintenance knocking my door yet. So once they knock, I'm gonna run as fast as I can over there with my bug spray.
Okay. Okay. Well, we're going to start off on, well, while you're doing that, we're going to start off on New York Times versus Sullivan.
I'm gonna briefly read this for a bit. Just keep an eye over there. So West Texas University students, according to the article, Bear Bright and Marcus Silva have held their breath. They said, University President Walter Wender canceled last year's campus show. There's a lawsuit thinking it violates First Amendment. And let's see. So it's basically they're saying they want freedom of expression on let's look on a campus. And hang on. So there.
Mm-hmm. So their case is pending in the Fifth Circuit Court of Appeals, and they were trying to go ahead and have it this year. Is that right?
Yeah. I'm still listening.
Um, so basically what this case involves is that as long as as their challenge to Wendler's action, it was still pending before the appeals court, that Wendler still was able to forbid the drag show from being performed on campus until the appeals court answers has a final opinion on their challenge. So that they're claiming their First Amendment rights are violated by this challenge, by Wendler's action. What do you think? What do you think? Do you think Wendler violated their First Amendment rights by canceling the drag show? Wendler is clearly a government actor. It's a public university that he's in charge of.
It's a public school, right? Owned by the state.
Yep. And I think Texas doesn't Texas have a law that let's see. I think Texas has a law that says no drag shows. Let's see. Republican lawmakers attempted to classify all drag shows as obscene. Let's see. There was a watered down version. Senate Bill 12 was passed. But that was found to be unconstitutionally overbroad and vague. And then now that's being appealed to the Fifth Circuit. So these guys have won in the lower court, but they still can't have the drag show until the case is finalized. Yeah, it's an interesting case. And this whole issue about so the Fifth Circuit Court of Appeals is a very conservative circuit down in Texas and Louisiana. And there's another case where there's a question of whether or not there have been a series of cases this year where conservative decisions of the Fifth Circuit Court of Appeals have been appealed to the Supreme Court, and the Supreme Court has been asked to stay their implementation. Like, for example, that an example of that would be the social media platform suit that I sent you guys a copy of what I wrote about. This was a suit involving Missouri and Louisiana suing the Biden administration for putting pressure on social media platforms to take down false and dangerous posts. And the Fifth Circuit Court of Appeals had upheld a Louisiana, parts of a Louisiana judge's Trump appointee's decision, saying that violated the First Amendment because the government pressure on the social media companies was government coercion, and therefore brought in government action and a violation of the First Amendment. Well, the Supreme Court in that case, while it was being appealed up the line, agreed with the Biden administration that the Fifth Circuit Court of Appeals' decision could not be implemented while they considered the case. And it's pretty clear from the oral argument on this past Monday that a majority of the justices, if you put together the conservatives and the liberals, disagree with Missouri and Louisiana and think that the federal government has the authority to pressure social media companies to take out false and or dangerous posts from without violating the First Amendment. I mean, we'll see when they actually issue the decision later this year, but that's the way it looks like it's gonna go. So this case about the drag case, it sort of also involves this question of while a case is dragging out through the appeals court, when should the lower court decision go into effect? And so for the time being, the lower court decision that said Texas's law banning drag shows is unconstitutional violation of the First Amendment, that's not going into effect while it's still being appealed through the Fifth Circuit. We'll see how this all plays out. Anything else in the news to talk about before we go on to New York Times versus Sullivan? Are you guys able to hear me okay? Okay.
Yeah.
Let me give you guys credit for being online here. Although I think you're both getting to sort of the limit of this extra credit here. And you both have your, yeah, I just reached the, okay. I gave you credit for being here. And
But I have a question.
sure.
In this era of proliferation of social media, if you see this issue of TikTok, do you think if TikTok is banned maybe in a country like US, as other countries are now attempting to block TikTok, do you think it's not an attack to First Amendment?
I think that's going to be a really, I initially thought that it would clearly violate the First Amendment. But then as I thought about it more, if Congress bases its decision upon national security, which seems to be the objection that they keep repeating. If they base it on national security, the Supreme Court would give that a lot of weight. I mean, think about Korematsu versus the United States. Even though the Supreme Court now admits that that was wrongly decided, that was a national security issue. Or think about the draft card, US versus O'Brien, the draft card burning case, where the national security of operating a draft during the Vietnam War was at stake. So even though it would seem to violate the First Amendment, the national security end of things, maybe Congress's action would be upheld. I think the House has passed a ban. And so I think it's over in the Senate. I think that, Biden has indicated he's for some sort of ban. I don't know if he's for the form of it that exists right now. So we'll see. I mean, I watch TikTok every day, in one form or another. But I think they might be able to uphold a ban on TikTok, even though on national security grounds, even though I'm not 100% persuaded that the Chinese Communist Party is using its access to the to TikTok records to harm U.S. national security. I don't think there's a lot of evidence of that.
Over there, I just heard something. I'm not sure it was there. Saw it. There was something, not sure it was gone or blew away. You can keep going.
Have you solved your problem, Paul?
Yeah, we're working on the problem.
Okay, good. Okay, so it was interesting though, the TikTok came up in that social media case where the hypothetical from Justice Jackson was about kids jumping out of windows based on a TikTok contest. You know, the hypothetical Justice Jackson asked Louisiana was, what if TikTok had a contest that said you win a prize if you're a child who jumps out of a window, and the higher the window, the higher window wins. And the kids then started doing that, and kids were jumping out of windows and hurting themselves and dying. Uh, could the government warn TikTok that they should take it down? And Louisiana said no. The Louisiana Solicitor General basically said no. That would be a censoring based upon the content, and that's a violation of the First Amendment, so you couldn't do it. Didn't seem as though the justices agreed.
Huh?
They still, because of why? Because they said, well, Chief Justice Roberts said that wouldn't really be based upon the content um, of the TikTok posting. And and basically the six justices who look like they'll be in the majority, the three Democratic appointed justices, plus Roberts, Kavanaugh, and Barrett, they all said that it's been common practice forever for government officials to call up media and say, hey, you've got this story wrong, or if you publish this story, you're going to you're going to disclose the name of a spy, or you're going to, put American troops in someplace in danger. I mean, those, or that this particular false health information about vaccinations is going to cause people to die. These are common. This is common jawboning. It's sort of referred to that government officials engage in for the health and safety of people. That the St. Petersburg based Russian hackers working for Russian intelligence, that their postings are potentially dangerous, are are false. All these are things that the government has forever warned social media platforms and the press before them. You remember that? Remember that one NSA case that we talked about, where this is where the Bush administration had been wiretapping Americans' conversations overseas using the NSA, and President Bush invited the New York Times publisher and Washington bureau chief and editor into the White House and told them that if they disclosed that the NSA was wiretapping conversations of Americans with citizens abroad, that would let Al Qaeda know how the U.S. was foiling their various attack plans, and there would be future attacks by Al Qaeda. And if that happened, then the New York Times disclosure of that information would mean that the New York Times would have blood on their hands in the death of Americans from the attacks. I mean, that's a good example of when government officials, long before social media platforms, not long before, 2006 is when that happened. That was before there was any kind of widespread use of social media platforms. The federal government jawboned New York Times, traditional journalism platforms like the New York Times, not to publish it. And New York Times went ahead, and there were no attacks. Yeah, so it was another one of those examples of where the government, it was an example of where the government was exaggerating the danger. But it is certainly within 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 the rights of the government to speak when they think that is false information or dangerous information being conveyed on social media platforms. So we'll see what the Supreme Court opinion event decides in June, when it probably will be released. But most likely Louisiana and Missouri are going to lose, and the Biden administration is going to win. It might be, though, that they may not even make the decision based upon the merits of the case, because there was also a question about whether or not Missouri and Louisiana had the standing to sue, or are any of the other of the posters whose posts were taken down by the social media companies, because there wasn't necessarily enough proof that complaints from the Biden administration officials had led to any of the actions taking down the posts. So we'll say they could decide it on the procedural basis of Missouri, Louisiana, and the posters don't have legal standing to sue, because they can't show a clear link between the Biden administration pressure on the social media companies to take down posts and any particular posts of theirs that were taken down. And Louisiana and Missouri, they have an even more sort of attenuated argument, because they didn't make any posts themselves that were taken down. I'm sorry?
Well, I'm not sure if we're hiding.
We're not hearing you clearly, Paul. We're not seeing you clearly either.
He's talking to somebody in the house.
Okay, are you back?
Right here. Let's see.
Okay. So are you safe now from the WASP?
Yeah, we're checking. I'm still listening.
Okay. Okay, so let's move on to New York Times versus Sullivan. This is one of the most important First Amendment cases the Supreme Court's ever decided. It and Pentagon Papers, New York Times versus the United States, are probably the two most important. And so does somebody want to describe the civil rights background of New York Times versus Sullivan?
After reading this case, I placed this in the context of civil rights movement. That's where I found this case emerging, as the New York Times published that ad, and what Sullivan did, even if it was not mentioned in the ad, was that he felt that he was concerned about what was in that ad. So then they took the case to the Court of Alabama, if I remember. And then the Court of Alabama awarded like 500,000 USD as a reward, saying that they won the case. But the New York Times was not happy with that. They took that case to the Supreme Court. When it arrived in the Supreme Court, they had a different judgment or different decision compared to what happened in Alabama court. So what happened is that the Supreme Court said that they should prove that they were the actual malice, if I remember what they used in that decision of the court. They said that they should prove that that ad had an impact on them, like on their personalities. So that's what I remember from this case. But I found it interesting because it's hard for the public figures, as I said, in the case of Donald Trump, to win the case about defamation.
Correct.
Yeah, there's just a hairline crack there. Sometimes
So,
there's
so
a,
say that again.
Um, it seems that according to the decision of the court about this case of New York Times and Sullivan, it's hard for public figures to win the case about defamation. They have to prove that there was something that is going to harm their personality so that they can award or maybe decide in their favor.
Right.
profitable.
So New York Times versus Sullivan makes it harder for a person in Donald Trump's position to win a defamation suit like the one he brought against last week against Eugene Carroll. That's true. Because it sets a higher legal standard.
No.
He has to show not only that he was harmed, but that it was done with actual malice, which means reckless disregard for the truth, knowledge of falsity.
It's getting
Um,
warm.
But another thing, as my own interpretation, I think the Supreme Court decided in that way for defending the press in the US. I think if they didn't support New York Times, that could damage the image of the press in this country. Because I think if they did and then say that New York Times did a mistake, that could harm other media organizations in the future. I think maybe that was the reason why they couldn't maybe say that New York Times did a mistake by publishing that ad, because they confirmed that there were some false information in the ad already. So, but I think they had to defend the press as a whole. That's what I thought about it.
and why did they have to defend the press as a whole?
I think they had to defend the press as a whole because the Constitution itself protects the press in this country. That's number one. Number two, the press is also the fourth state. By damaging a media organization like New York Times, that could have an impact on the whole press in this country in the future. That's what I thought. That was my own interpretation. That was not written in the decision, but I think that was also behind that.
What was going on? What was the state? What kind of situation did the press face in the South at the time of New York Times versus Sullivan?
I don't have precision about that.
Well, this was at a time, so this was the New York Times versus Sullivan decision was 1964. And that timing is important. So this case comes along, this $500,000 judgment that you described correctly in the federal court in Alabama comes across at a time when Southern segregationist politicians were suing the media, the New York Times, CBS, other national news organizations in courts all around the South and trying to use the defamation laws to get big libel judgments. And because they wanted to get the national press out of the South, because the press was a big factor in turning Americans against the segregationist officials in the South. There was another sheriff, his name was Bull Connor, who got a lot of press coverage at this time for putting fire hoses on young student protesters, using ferocious police dogs to threaten young teenage protesters. And that was occurring in Birmingham, Alabama. Alabama had a governor, his name was George Wallace, who gave a speech, segregation now, segregation forever. He ran for president in 1968 and 1972. And this is a period of time when James Meredith, in order to get James Meredith into the University of Mississippi as the first black student, President Kennedy had to send the National Guard. But the press faced hundreds of thousands of dollars, even millions of dollars of defamation judgments, not just in this particular case of New York Times versus Sullivan, but in other places in the South as well. And so I think the press saw, and the Supreme Court agreed that there was a threat to the press in slapping them with a $500,000 judgment based upon a few careless mistakes in an ad in the New York Times. What were the mistakes?
I think that there was no mistake in that. There was no mistake in that because the press has to be defended. When I take into account your comments about the context of the press in the South in that time, that was the right decision to take. Because if they took the decision for punishing New York Times, that could even give a kind of power to the extremist groups for attacking even media and use it as a weapon for them, maybe finding some media organization that will support their ideology. But I think by defending New York Times, that was great because media felt somehow comfortable, and also media felt somehow comfortable in general. When I took into account your comments about the context of media in that time of 1960s.
Yeah, it was. I mean, it was a time when there were all sorts of threats to not only civil rights protesters, but also the journalists. I mean, this is the period of time when little girls were in the basement of the 16th Street Baptist Church in Birmingham, Alabama, were blown up by a Ku Klux Klan dynamite bomb. A protester, there were freedom riders, civil rights demonstrators in Mississippi who were killed by the Klan, buried in a dam there. At the Pettus Bridge in Alabama, protesters marching for voting rights were beaten by the police. That included John Lewis, who went on to become a representative congressman. So this is the context was one of violence and also where the press disclosure of the segregationists actions was turning much of America against the segregationists. The decision was announced after the year after Martin Luther King's March on Washington in 1963, sort of his famous march where he said, he gave the I have a dream speech. It was New York Times versus Sullivan was announced before the summer of 1964, when the Civil Rights Act of 1964 was passed, outlawing discrimination in public accommodations and restaurants, swimming pools, employment, etc. And the mistakes in the ad. So this was an ad, Heed Their Rising Voices. It was a full-page ad in the New York Times that called upon people to support civil rights demonstrators in the South. And the kinds of mistakes they had where they had wrong number of, this was an ad, by the way, that was placed by the National Civil Rights Leadership, supported by people like Harry Belafonte, sort of celebrities, Sidney Poitier, I believe, black media personalities. And the kinds of mistakes that this libel judgment was based upon were minor ones relating to what patriotic song were students singing in the protests, how many times had Martin Luther King been locked up for his protests. I think they had said 7 and it was actually 4. So very minor mistakes that had led to this $500,000 judgment. And there were judgments all against national media all across the South until after New York Times versus Sullivan was announced. Justice Brennan, the spark plug of the liberals on the court, actually he was a Republican appointee of Dwight Eisenhower's. Brennan wrote the opinion. He said that the First Amendment required there to be breathing room for the press to make minor mistakes of this kind, and that's why they had to raise the burden of a public official to prove libel and defamation. They had to raise it to actual malice, make it harder for the public official to win. They also pointed out that public officials have easy access to the press. So if they've been falsely accused, they can easily say, "Oh, that was wrong. That was unfair." So they had an easy way to rebut allegations against them. Questions about New York Times versus Sullivan? This was actually a time when the press wasn't actually that popular with the justices on the Supreme Court at this time. For one, this was a period of time when there are lots of investigations going on of Abe Fortas, who President Johnson named to be the Chief Justice, and he had engaged in some activities representing clients that were portrayed as being violations of conflict of interest, and he was forced to give up, to give up his the nomination for the Chief Justice, and then to actually leave the court entirely. So amongst the justices on the Supreme Court, there wasn't a lot of love for the press. Nevertheless, this decision was 9-0. But people thought that that the Supreme Court could pull back from New York Times versus Sullivan because it was such sort of a revolutionary from constitutional law viewpoint. It was pretty revolutionary. All up until the time of New York Times versus Sullivan, defamation was a state matter. And so to put this national overlay, constitutional overlay onto what had always been a state matter was quite a change. And one of those who was critical was William Rehnquist. But ironically, or maybe fittingly, it was Rehnquist who ended up writing the opinion in Hustler v. Falwell that applied the New York Times versus Sullivan. Does anybody want to describe Hustler v. Falwell? You started the other day, Paul, with a little bit on that, but I don't know if you want to describe that case or not.
Let me find him first. Let's see, he's got to be here somewhere.
I'll give a little bit of background in that Falwell was Jerry Falwell, whose son, by the way, now runs Liberty University in South Carolina. But Jerry Falwell was the head of what was called the Moral Majority. And this was a group of conservative religious, conservative ministers and other religious folks who gained a lot of political power at the time that Ronald Reagan was elected. The moral majority, as they were called, was considered to be an important factor in Ronald Reagan beating Jimmy Carter, even though Jimmy Carter called himself a born again Christian. And so Jerry Falwell was a famous, probably one of the two most famous ministers in the country, Billy Graham probably being the most famous at this time. And so Larry Flint was a pornographer. And in his pornographic magazine, he had a parody about Jerry Falwell that said that Falwell had had sex for the first time when with his mother in an outhouse, all of which was false, and patently false. And at the bottom of that ad it said a parody in fairly small print. And Falwell won in the lower court, just sort of like Sullivan had in the case, the New York Times versus Sullivan. So Falwell won in the lower court. His claim was that he had been subject to, it wasn't a libel case, it was that he had been subject to infliction of emotional distress. And the Supreme Court ruled against him, and Chief Justice Rehnquist wrote the opinion of the court. I talked to one of the lawyers in that case at a conference one time. It was a female lawyer who had written a friend of the court brief, on behalf of America's cartoonists. And she told me that, political cartoonists, she told me that they had found out that Rehnquist, when he was at Stanford as a law school student, had a great interest in political cartooning. As an aside, and this comes up on a test, he was at Stanford Law School at the same time as Justice Sandra Day O'Connor. As a matter of fact, they went out on a date together. Rehnquist finished up first in his class, O'Connor third. O'Connor couldn't get a job when she left because she was a woman, and all they would hire her for was secretarial duty. At any rate, back to Hustler v. Falwell. So this lawyer I talked to said they had discovered that Rehnquist had this great interest in cartooning. So they put together a whole friend of the court brief that had all sorts of cartoons, way back to the famous 19th century cartoons on the Tweed machine in political machine in New York City, the cartoons that Rehnquist really loved. They kept out a cartoon that showed Rehnquist in a Ku Klux Klan sheet denying minorities in Arizona a chance to vote in a presidential election. That was one of the controversial issues that Rehnquist had to deal with, both when he was originally nominated for the court by Nixon in 69 or 70, and then later when he was nominated to be Chief Justice in the early 1980s. This lawyer who was putting together this friend of the court brief to persuade Rehnquist said that they made sure they didn't include the cartoon of Rehnquist dressed up as a Ku Klux Klan person denying minorities the right to vote. Although Rehnquist had a pretty good sense of humor. At any rate, so what was really sort of amazing from a couple of points of view was that Rehnquist writes this opinion in favor of Flint, the pornographer, saying that parody is especially protected, that even though this is a poor cousin to political cartoons, that there's a proud history of political cartooning in the United States, and these kinds of parodies got protection. Parodies basically get more protection. Parody, hyperbole, if something is clearly hyperbole, exaggeration, it gets more legal protection, just as does satire and other kinds of and parodies. We'll see when we get the copyright in a few weeks. We'll see that happens too in connection with copyright. There was a question that snuck its way on to the first test. It really should have been on a later test, about how the Two Live Crew parody of the Pretty Woman ballad got protection from the Supreme Court because of it being a parody, and Roy Orbison lost his copyright claim against them. But so one thing was amazing that Rehnquist ruled for the pornographer and against the conservative leader of the moral majority. The other thing was that even though he had criticized New York Times versus Sullivan's actual malice standard, he applied it to this case. And the third thing that makes that even more outstanding is that clearly the Hustler magazine that published the parody knew that all the facts in the ad were wrong. So they had knowledge of falsity. I mean, it even fits the New York Times versus actual malice standard. But the fact that Rehnquist embraced New York Times versus Sullivan was seen by the legal community as saying New York Times versus Sullivan was safe. It wasn't ever going to get overruled. Of course, Donald Trump in his 2016 election campaign said that the libel laws should be altered so that it was easier to win libel judgments. Of course, I'm not sure what he thought in that connection after Gene Carroll won a defamation judgment against him. But even with the higher standard of New York Times versus Sullivan. The other thing to know about New York Times versus Sullivan is that was about public officials. Sullivan was a public official. He was head of the Department of Public Safety in Alabama. But the Supreme Court soon extended it to include public figures as well, although it's always been a little bit unclear who is a public figure. And there's some quirks to that, like firefighters are not considered public figures, but police officers are, because they exercise deadly force. So it's a little bit of a case-by-case basis. A Justice Department lawyer who was the head of the organized crime task force in the Justice Department was a public figure for the purposes of his time in the Justice Department, but then when he went back to his hometown to be a private lawyer, he was no longer considered to be a public figure. So it can vary depending on the circumstances. Any questions about defamation and libel? I'm glad your wasp danger has been cleared. That is a great relief for us, Paul. Do you have anything to add about Falwell versus Flint, Paul?
Oh yeah. Get my notes back. And I lost it now. So follow suit Larry Flint and get the scene right. It's weird. Hang on. Just had it. FAD. Baseball again? I froze. I know.
What do you want spelled?
Fodwell.
Falwell, Falwell.
W. Okay.
It was
Yeah.
the case is called Hustler v. Falwell.
My computer's kind of freezing up a bit, but it's something to do with oh, it's working now. All right, so according to this, my notes, forget where I came from. Jerry Falwell versus Larry Flint. It was the first sexual experience. My interview rendered. Say it. Jerry Falwell that I never really expected to make it with mom, but then after she showed all the other guys in the town such a good time, I thought, what the hell? So it looks like even though this encounter is false, Larry Flynn said it was a parody, but I guess my guess why it's not a slander is because he didn't say that it happened. It just made it like a parody, like a joke.
Right.
But
It-
it's what happened. I would assume he would have got Larry would have got in trouble for slander or libel.
if he hadn't marked it as a parody and hadn't
Yeah.
been clearly a parody, then he probably would have lost the case. But
Yeah.
parody gets extra protection and it gets the same kind of level of protection as New York Times versus Sullivan. So that's the thing to remember. Do you two guys have your plans for what you're going to do for your project at the end?
Yeah.
The Chicago 7 trial.
So what are you planning?
I'm gonna summarize a bit of the Chicago 7 trial.
Oh, Chicago 7 trial. Okay, great. That'll be great. And make sure you do it in sort of like the context of the period of time, right at I believe it was right after the 1968 Democratic National Convention where there were riots in the streets. The press at the time called them student riots. Many of the reporters on the scene thought it was police riots, where police were anxious to beat up students. Friend of mine, long dead, who was covering that, told the story of, which is depicted in the movie, of the police pushing him through a plate glass window into a bar, him and other protesters he was covering, through a plate glass window into a bar, where some reporters, not working as hard as he, were instead drowning their sorrows. So that'd be a good background. You have any questions of me on that, Paul?
I did have a reference in my paper that someone talked to one of the guys, John Weiner, that's his name. But when I try to quote it, I don't know who to quote. I quote the author or the guy. So usually I like to put quotes and summarize them. But I want to use Weiner's quotes so much, but it's kind of hard because who do I give the credit to?
Well, this is a quote from the movie?
From the article from NPR.
Oh, well, I mean, just say, you can just use the quote and then you could put in parentheses NPR and the date. That'll be fine.
Okay. All right.
All right. How about you? What's your project on?
Well, I'm always interested in the broadcasting, especially broadcasting and development, socioeconomic development, by focusing on Global South. And I was lucky in this class because there are things that I didn't pay attention to. especially radio in the 20s when radio was starting up to the 40s. So in this class, I want to explore regulation of radio, especially broadcast from the 20s up to the 40s by exploring how media was restricted in those years by having the case studies of the US, Europe, and Global South. But Global South is not going to have a lot of literature because radio was still starting in the Global South. It was still a colonial tool. So in this class, I want to explore the regulations of broadcasting from the 20s up to 45 as part of my literature for my final, for my thesis. I think that was great for this class because I didn't pay attention to the starting of broadcasting from the 20s up to 45, especially the policy during World War I and World War II.
Right. I think that's a great topic. Look at, let me see if I can get this up real quick. Look at the syllabus.
Okay.
We get down to more broadcasting stuff later on. I mean, soon we'll be at FCC versus Pacifica, which is George Carlin's 7 Dirty Words. But when you're getting into that earlier history, look at some of the readings on, let's see, where is this?
Yeah, I think I saw something like that in the first weeks of this class.
I think I may have to go back and get some of the some of those early Supreme Court cases. Initially the Supreme Court didn't protect like movies. Didn't consider that to be protected by the First Amendment. And there's sort of a very famous case from the 50s that was a film that sort of made fun of the Virgin Mary. But let me see if I can find real quick. An old syllabus.
I think it's on week 14.
I'm sorry, I didn't hear you.
Radio, like broadcasting, was on week 14.
Yeah, I see week 4, but I don't. It looks to me like I have not included on this syllabus some things that I used to. Okay. And I'll tell you what I'll do is I'll send you some of that with a separate by a separate email when I find it. I'm not finding it right off the top of my head here. Oh, here we go. Here's an older syllabus. Let me see if this has it real quick. Yeah, it looks like I'll have to go back farther. I'll send that to you separately. But yeah, I think that's I think those are both really good ideas for projects. And any other questions? Okay, well, so we'll see you next week, and we'll be doing the next lesson, schoolhouse speech. The key cases there are Tinker versus Des Moines, little Mary Beth Tinker wearing a black armband to high school in Des Moines, Iowa, protesting the Vietnam War. Kathy Kuhlmeyer versus Hazelwood, which is a case that I covered in the Supreme Court. Kathy Kuhlmeyer, the editor of her high school paper, defending a 2-page spread on how divorce and access to birth control and et cetera affected teenagers. And then a number of more modern cases, Bethel versus Frazier, a kid who had a campaign speech for a fellow student where he had sexual innuendo, bong hits for Jesus, Olympic torch ceremony where a kid held a banner, bong hits for Jesus, along the path of the run, the Olympic torch run. And then the most recent one, where the Supreme Court upheld the First Amendment rights of a disappointed cheerleader contestant who on her social media said, fuck cheer, fuck, fuck the cheer squad or something like that. And the Supreme Court upheld that. So that's what we'll go to next week. See y'all then.